Crisis Radio. Now, traditionally, over the past 15 months, one indispensable feature of our weekly reports to you is a report from the legal front, the attempt to expose the non-qualification of Barack Hussein Obama, a.k.a. Barry Sotero, not qualified for the presidency. And for that, we go directly to the leading expert in the field, Phil Berg of Philadelphia. Welcome, Phil. Please give us the news of the week.
Well, the news of the week progressing slowly, but we were supposed to have argument this past Monday in the Third Circuit Court of Appeals. But I believe I told you last week they decided they're going to handle the case without oral argument. I'm not sure why, but on the briefs, it could be they didn't want publicity or who knows why. A lot of times it's done in many cases, though, so I'm not taking it as a negative. Also, it's given us an opportunity twice this week to sent judicial notice to the Third Circuit Court of Appeals of Judge Carter's statements, one his statement and one part of his ruling in the California case, which unfortunately he just dismissed for lack of standing. But he brought up a very interesting point, and he got the U.S. Attorney and the Attorney General's Office of the United States to admit that there would be standing if the case had been filed before the election. In the case out in California, it's the Wiley Drake case, and it was filed by Orly Tates, who I have so many negative comments to talk about, but Orly Tates filed it on the afternoon of January 20th after Obama became president, and the judge said, well, that's now it's different. The court should not have any effect on that. It'd be up to Congress. But he did get the U.S. Attorney and the Attorney General's Office to admit that if it was done before the election, there would be standing. Well, I filed mine August 21st, 2008, so we asked that the Third Circuit Court of Appeals take judicial notice of the judges in the California case opinion that there would be standing. So I'm hopeful it's another notch in our direction.
Great. So what is that? That they're accusing her of laches, right? If you don't assert your rights in a timely way, you've waived them?
Yes, well, in a way, but they're also, they're saying that basically once she's sworn in, it's a matter for Congress. And our position is that that's wrong anyhow because he's a usurper. He has no business being there. But our strength is based upon what Judge Carter said, and that is not what Judge Carter specifically asked questions of the U.S. Attorney for the United States, representative, and representative of the U.S. Justice Department, and they basically came out and said, yes, there would be standing if the action had been filed before the election. Well, I filed my case before the election, so I'm hoping
absolutely.
Then that you never know. So we're proceeding. That's the Third Circuit. We just gave them the second. Right now, we're doing a judicial notice of the opinion that came out yesterday, where Judge Carter dismissed the case for lack of standing. But he basically crucified Orly Tates for her actions or inactions or inappropriateness. And I think it's time that everyone in this movement, call us birthers, whatever you want to call it, tell Orly Tates we're done with you. Because she's been a total embarrassment to the legal profession. She's been a total embarrassment to this cause. She was fined, sanctioned $20,000 in the Georgia case, and here the Judge Carter in the California case has really chastised her for her lack of proper service of the complaint, her procedural nightmare, and also her remarks, and also she directed many people to call the judge's chambers to try to influence him, and that's just not what you do as an attorney. And I really think she's a plant. I think she's been a plant. I don't know if she's being paid for by Obama or someone else supporting his position. It's time that people shun her, let her stop giving her any attention because she's a nightmare, and let's stay focused like I've been since the beginning. The place to go is obamacrimes.com, OBAMACRIMES, obamacrimes.com. We are focused. So I feel encouraged on that case, and we still have our two other cases in the D.C. Circuit Court of Appeals. We are proceeding, one on the interpleader action by retired Air Force Colonel Hollister, and the other on our False Claims Act, stating that we believe that Obama is not only not natural born, he's not naturalized, he's an illegal alien, therefore he cannot serve as president, nor could he serve as the United States Senator from Illinois. Therefore, all the money that he received should be returned to the U.S. Treasury, and that's totaling $1 million, plus the money's now, because if I'm correct that he can't be a U.S. Senator, he obviously can't be a U.S. President, and it's really outrageous that we're about to go into November 2009, and we still know nothing about Obama. As we discussed before, we don't even know if he's really born August 4th, 1961, because we've never seen any legitimate document documenting that. The only thing we saw is the phony document, Kolb, which they put on their campaign website in June of 2008, and it really is outrageous.
Well, you have the merit, of course, of having put your legal action in at the Supreme Court, not only before the election, but indeed before the Democratic National Convention even nominated Obama for the presidency. So you are essentially, you've done it all in a timely way. And what do we know? What Orly Tates' reason for waiting until the afternoon when Obama was already in power? Was there some reason for that?
No, in that particular case, she filed it, and she didn't even have permission from some of her clients to file it. Really, she's a nightmare. She's a total disgrace. And you've known me a long time. I don't down other attorneys. I respect other attorneys' opinion. But this Orly Tates has done everything to hurt this movement, by accusing the Supreme Court of hiding her file, by writing letters to the FBI and CIA asking them to investigate the U.S. Supreme Court. Why I didn't agree with the Supreme Court ruling denying my application for injunctions, they're doing their job. They're doing what they think is best. And I'm hoping that my case is now that if they get before the U.S. Supreme Court, that they hear the case on the merits, because I really believe, and not because I filed it, but these cases are the most significant cases in the history of our country, and it deals with an absolute hoax put forth by a person and people behind him on the citizens of this country, and it's a disgrace. And seriously, Orly Tates, she is a disgrace. She's an embarrassment, and I really think that one of these days she's going to get disbarred in California for all the action she's done in this case. It's outrageous I'm sure next she's going to take on Judge Carter as she took on Judge Land. Judge Land had given a rule to show cause why he should not impose a $10,000 fine against her. On the last day for filing, she files for an extension and also files a motion that he recuse himself, accusing him of all kinds of falsities, and I'm sure she's going to go after Judge Carter now. The problem has been in how the case are being presented by Orly Tates. Those Georgia cases were based on military people that also filed as conscientious objectors, and then a conscientious objector is not sent to a war zone. And then she was trying to she came up and said that therefore the military caved into her. And this California case, she even put out a press release the other day how there's going to be a hearing in January. She doesn't know what she's talking about, and she, on the other hand, she just misleads information.
Thank you very much, Phil. We'll be looking forward to hearing from you again next week.
Okay, thanks. ObamaCrimes.com. Send us some money.
Absolutely.
Thank you.